Hi there guys, this is the First of the Law podcast. We're going to do Law Paper 2 and we're going to look at delegated legislation. Now, instantly, when you think about delegated, you think something's been passed on. So here, normal lawmaking power is passed on to other institutions or individuals in order to make law. That's why delegated legislation is referred to as secondary legislation. Now, in order for that legislation to be made, please remember, there must be a pre-existing act that gives the power for someone else to make law. Now that we refer to as a parent act. When we talk about delegated legislation, there are three main sources of delegated legislation, and you will need to know in detail all three. So the first of these are bylaws. Now, bylaws, remember, are made by the local council or public bodies, and they only regulate in that specific area. So we say they have local effect. Now, the most famous bylaw you probably remember is the one in Manchester in 2002, where they banned drinking in the town centre during the Commonwealth Games. Now, there are a whole other range of bylaws that you could link into. So you could talk about dog fouling, you could talk about parking restrictions. But if you remember at least the Commonwealth Game ones, you should be okay. When we talk about public corporations and public bodies, that could be organisations like Transport for London. But your example that you've got in the notes that probably will help you out the most is the National Trusts Act of 1907 and 2005. Now, these acts allow the National Trust to regulate like access to their properties, cost of their properties, and whether they can allow dogs on site because they own the land. So they're allowed to regulate what they do on National Trust property. So that's bylaws. They're your first type. They have local effect. The second type are something called statutory instruments. Now, these are laws made by government ministers who are part of an individual department. So this could be, for example, the Home Secretary, who is responsible for the Home Office. Now, when you talk about examples here, there are a whole range, but try to remember at least three. Also, please remember that statutory instruments have whole effect. So they, as soon as they're made, can impact the whole country. So the famous examples that I can go into, the Dangerous Dogs Act of 1991 allowed the Home Secretary to add more breeds of dangerous dogs to the Act if they deemed it necessary to do so. The second one, the Department for Agriculture, they were able to close public footpaths during the foot and mouth outbreak. And that was back in around 2002. The more recent one that I would want you all to refer to is the National Minimum Wage Amendment Regulations of 2016, and I believe there's one of 2018 and 19, which raises the minimum wage for individuals. So that is your second type. The third and final type of delegated legislation is something called Orders in Council. Now, these are laws passed in the name of the Queen by the Privy Council. The Privy Council are made up of senior politicians, and normally they make laws when Parliament are not actually sitting. So usually they're dealing with things like emergencies when Parliament are not sitting, and that will be governed under the Civil Contingency Act of 2004. But the Privy Council can do more in terms of making secondary law. They can also give effect to European directives, and they can transfer responsibility between government departments. And probably the most famous example you remember is they deal with some updates to certain laws. So, for example, the Misuse of Drugs Act, they decided to change cannabis to a Class C drug, only then for 5 years later to be changed back to a Class B drug. So they are your three types. That might come up in a 10 marker on its own. You need to explain the effect that all of those different sources of secondary law have, and you need to give me examples. Just for the record, Orders in Council, whole effect; statutory instruments, whole effect; bylaws, local effect. So your second 10 marker that you could be asked for an explanation question are the potential controls that we have on delegated legislation. Now, this could be a really, really specific question where it asks you explain the parliamentary controls on delegated or explain the judicial controls on delegated. If it's a generic question, then know that you'll need to talk about both, but you can afford a little bit less detail when you're doing those discussions. So let's, for the purposes of this, start with parliamentary powers to control delegated legislation. Now, please remember, one of the most important things is that Parliament has set a Parent Act. So Parliament, in theory, can repeal that Parent Act at any time they choose to. So that's really important. So they can just wipe away that power, but that's quite a long process, because if you remember rightly, actually getting a law through potentially can take up to a year. So Parliament might instead use the various committees that they have to scrutinise and check the delegated legislation. Now, we have a range of committees that focus specifically on delegated legislation, and you'll need to at least talk about one of them. The first one is the Joint Committee on Statutory Instruments and the Secondary Legislation Scrutiny Committee in the House of Lords. We also have the Delegated Powers Scrutiny Committee. They obviously will focus on all laws, whereas some of the ones that I referred to in the statutory instruments, they're just going to focus on statutory instruments. Now, they will feed back to Parliament if they're not too happy with any of the delegated legislation, but they cannot change anything. So that's really important when you talk about how effective they are, because they just can't do anything. All they're doing is just referring the issue back to Parliament. Now, the more complicated bit comes when we talk about the procedures that might be set out. Now, the first of these procedures is set out in the Enabling Act, or the Parent Act, and it's called the Affirmative Resolution Procedure. Now, all that means is that both Houses of Parliament must vote on any changes through secondary law before it comes into actually becoming law. Now, this is usually done within really, really important changes in the law. So the Parent Act will try to protect unfair changes in the law. So one of the classic examples of this is the Police and Criminal Evidence Act. Now, that requires that any statutory instrument made must be approved by both houses. The second form of procedure that you're looking at is something called the Negative Resolution Procedure. Now, this is usually specifically for statutory instruments, and they will become law unless they are struck down by either House of Parliament within 40 days. Now, 40 days sounds like a long time, but unfortunately, the likelihood of any of these being checked is actually very, very slim. So actually, even though they have this power, most of the time, they don't really take much notice. The third, and the one that you've probably got the most confusion with, is something called the Super Affirmative Resolution Procedure. Now, the Super Affirmative Resolution Procedure only affects delegated law that is made under the Legislative and Regulatory Reform Act of 2006. So really, really important, only specifically for that act. Now, under this procedure, it's quite long-winded. You first have to provide a memorandum for all of the consultation that you've had before you obviously implement your changes. You'll then have to take your memorandum to a committee from either House of Parliament, and they have 60 days to report on your draft. The committee can then make a series of recommendations, or they can tell you actually just scrap it altogether. After 60 days, you can then proceed with the draft without amendment, or you can obviously do your amendments. The worrying thing here is you can then have the affirmative approval by both houses. So you've already gone through all that checking, and then there's going to be a vote, and a committee then of either house can block your order. So very, 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 what's the word I'm looking for? Very strict rules that are enforced here, but you've got to remember this is only secondary law that is made under the Legislative and Regulatory Reform Act of 2006. The fourth and final way of parliamentary measures to check is something called questions in Parliament. Now, if you remember, you've probably seen it a little bit on the news, especially of late. Parliament will argue and they'll ask each other questions when all of Parliament are sitting. So that means you can request to ask a question to an individual minister. And that minister might have been the one that's actually gone for and made this delegated law. Now, there can be no effect that you can have by raising that. However, you're having that discussion in Parliament. It means that it can be questioned, it can be scrutinised, and it means that actually members of Parliament who might be part of one of those committees can now go away and look into it in more detail. The final types of controls then are judicial. So this will be things that we as individuals do to challenge unfair secondary law. Now, the key term here, or key terms I should say, are judicial review, because that is the process by which you make a challenge. And the normal challenge is something called ultra vires. This means the individual or organisation has acted outside of their powers. There are two types of ultra vires claims. The first ultra vires claim is something called substantive ultra vires. Now focus on the word substantive. That means the actual substance of the secondary law is outside of the powers that was granted under the Parent Act. Now you have two examples in your notes, and personally I always remember the Customs and Excise case versus Cure and Dealey over the Fire Brigade Union case. So I always remember Customs and Excise v Cure and Dealey. This was because what happened was Customs and Excise under the Finance Act were almost given the power to make any changes they wanted. And that was clearly wrong because it gave them more power than the actual government had. So Customs and Excise could put up charges however they saw fit. Whereas if it went through Parliament, there'd have had to have been a whole consultation. So the judges held that the Finance Act there and the provisions given to the Customs and Excise were actually unfair, and as a result they said that it was substantive ultra vires. The second type is procedural ultra vires. This is where the Parent Act sets out a specific procedure that needs to be followed when making secondary law. Now you will remember the classic case here. It's the Aylesbury mushrooms case. Now here, the Minister for Labour had to consult any organisation appearing to him to be representative of a substantial number of employers engaging in the activity. Here, he failed to consult the Mushroom Growers Association, which represented 85% of all mushroom growers. So therefore, the procedure was not followed because he didn't ask a significant majority. The third and final judicial challenge. This is something called unreasonableness. And unreasonableness comes from a very famous case. It comes from the Wednesbury Corporation case. Now the test for this means that the secondary law that is made was so unreasonable that no reasonable person would make such a law, and therefore the courts would quash it on the basis that it is unreasonable. Now we don't use the Wednesbury Corporation test case for its facts. We use it for the test. The key case that shows the test in action is the Rogers v Swindon NHS Trust. Now, if you remember rightly, this was a new breast cancer treatment drug, and it was only to be given out in exceptional circumstances. However, they didn't actually say or specify what the exceptional circumstances were. And actually, it just seemed like a way of just saying, you can have this, you can't. You can have this, you can't. Because some people who are very similar were getting different outcomes. That was held to be unreasonable because there was no real reasons why they had such a policy in the first place. That's your controls. Okay, so that is your second of your 10 markers, or potentially there's 3 10 markers there, because you could have the 10 marker on judicial controls, 10 marker on parliamentary controls. Your final question that you might have is looking at the advantages and disadvantages then of delegated legislation. This is more likely to be a 15 marker. So if we go through some of the advantages first, and I'll try and keep these as brief as I can. The first one is, please remember the delegated law is there in order to allow greater time to make specific laws. Parliament simply just does not have time to make the vast quantity of laws that is needed. So in order to bypass that, we have this delegated power so that ministers can act when they're actually in their own department areas. Also, it allows specific and more detail to be added. Let's face it, these individuals, especially for example ministers, they're meant to be experts in their specific area. So they should be able to add quite complicated technical details to law which other people just wouldn't know because they're not experts in this. So there is an example of this, and this one's quite a hard example to remember. There's the Air Navigation Order of 1995, which contained 140 pages of technical rules governing the flying of civil aircraft around the UK. Let's face it, what MPs know anything about that? Now also, if you remember, there is another example. This one's probably a little bit better to use. And this governs the Road Traffic Act, which is implemented obviously by the Transport Minister. And he could draw up any regulations that he wanted in relation to wearing protective helmets and what types of helmets were required. The only other thing that comes to with adding detail is also when we focus on bylaws. Now, bylaws, remember, allow local councils and local bodies to make law that just affects their local area. So that means we're going to be using local knowledge to solve local problems. So what's an issue somewhere will be a very different issue in other places. So, for example, North Somerset, we have bylaws that govern the seaside resorts of like Weston-super-Mare and what dogs can go on the beach at certain times. But obviously, Bath and North East Somerset don't require that. The final advantage that you can talk about is usually that it's easier to amend than an Act of Parliament. Delegated law can just be made quite quickly, quite snappy. Whereas if you're going to have an Act of Parliament and you want to make a small change to that Act of Parliament, then you're going to have to go through the whole lawmaking procedure, which can take a year and a half. So on to then the disadvantages. And we're going to use some keywords here. The first keyword is that classic undemocratic. It's kind of a bit of a breach of parliamentary sovereignty. You're giving power to other people to make law. That's not very good. Because these individuals might be unelected. Although, admittedly, we usually vote in our council and we do vote in the MPs, actually, the likelihood is that it's actually the government departments that are making the law for the MP or minister to actually present. It's not the minister himself that is making the law. So that means what we'd also call that procedure is something called sub-delegation. So that means you're actually been given the power specifically as the minister or body, and you're actually passing that power on to other people who you deem more expertise in that field. The only other things that we can talk about then are the large volume and lack of publicity of delegated legislation. There are literally thousands of pieces of delegated legislation every single year. Now, how often do you hear about a change in a bylaw? Probably very, very, very minor if you do, but it's incredibly unlikely. And actually that's the same in Parliament. It's very unlikely for Parliament to actually be told about a piece of delegated law. And usually where they are told, it's put in really difficult, confusing language. Similar to actually our Acts of Parliament, unfortunately delegated legislation is made in a very, very similar way. And actually the use of words can be obscure, and actually it can be overly complicated so that people do not specifically challenge it. Now, remember, that's a 15 marker. So you've got to put in key advantages and disadvantages. Focus on what the question's asking of you there, because it might want both, or it might just want one specific argument. Hopefully, that's okay. Please give me some feedback on how you found this. And hopefully, we'll have a few more of these. Bye.